Hearing you're going to represent yourself in this matter, sir?
Yes, sir.
I do have to advise you that in this case, you are charged with the offense of assaulting, resisting, or obstructing a police officer. That is a high court misdemeanor felony, punishable by up to 2 years and or $2,000 fine plus court costs. You understand that?
I understand your charge.
You understand also that there is great peril in one representing themselves. You understand that, sir?
I'm not afraid, Your Honor.
Did you understand what I just said? That there is great peril in representing oneself.
I comprehend what you're saying, Your Honor.
Tell you what. Either you're going to answer my questions and you're going to answer them properly, or we're going to have a long...
Buckle up, guys. Today we are going to break down a tense courtroom moment where confidence quickly turns into confrontation. From the very first exchange, the defendant introduces himself while choosing to represent himself against serious charges. The judge clearly outlines the risks and penalties, but the response, "I'm not afraid," instantly sets the tone. What begins as a routine procedure already carries tension, signaling this won't be a typical hearing. You can already sense a clash forming between authority and defiance. This opening moment lays a foundation for everything that follows. It's not just about the case, it's about attitude versus structure.
People wait. So while you decide how you're going to handle this, I'm going to have you have a seat. I'm going to pass your case. You will come back up and you will learn how to operate within this court. Plain and simple. Have a seat. Have a seat. And you might want to wipe that smirk off your face while you're doing it. State your name.
Good afternoon, Your Honor. My name is Daniel Magoo.
I have stated the admonishments that I was giving to the defendant representing himself. I apprised him of the maximum penalties and the charge.
From here, the dynamic shifts as the judge starts pressing for proper answers, but the defendant continues responding in a way that avoids direct acknowledgement. You can sense the judge's patience beginning to wear thin as respect and courtroom discipline come into focus. This isn't just about answering questions anymore. It's about authority, control, and whether the defendant is willing to follow the structure required in court. The tension slowly builds as each response feels slightly off. The judge is clearly trying to keep things simple, but the resistance creates friction. It becomes evident that this interaction won't resolve smoothly.
Yes. Surprised him, and sir, I'll ask you the question again. You understand that there can be great peril in representing yourself.
I fully recognize and acknowledge the seriousness of the charges, which include allegations of...
Not my question. You understand that there can be serious peril in representing yourself.
I recognize what you're saying, and I'm fully prepared to proceed with this matter.
Will you just do me a favor and answer my question? Do you understand that there is great peril in representing oneself?
I recognize that.
Okay, then stop there.
Yeah.
You recognize that.
Recognize.
Do you understand that that in any of the proceedings that the court would hold you for the same as if you were a practicing attorney, will give no leeway one way or the other, will show no favoritism or no bias because you are representing yourself. You understand that, sir?
I recognize what you're saying, Your Honor.
You know what? I don't know why you just won't understand. I'm asking you, and I need a direct answer, whether you understand what I am saying, not whether or not you're recognizing the words. Do you understand what I am saying?
I overstand what you're saying.
You want to be...
Your Honor.
Now things take a sharper turn as the exchange becomes a battle of wording rather than substance. The defendant repeatedly avoids saying, "I understand," choosing alternative phrasing that frustrates the judge. This may seem minor, but in a legal setting, clarity is everything. The judge recognizes this as a stalling tactic, and the tension rises quickly as the conversation loses its efficiency and starts becoming confrontational. What could have been a simple confirmation now turns into a prolonged dispute. This moment highlights how small choices in language can create big consequences. The courtroom begins to feel more tense with every second.
Have a seat.
I'm not...
Have a seat.
Your Honor, I haven't had... Have a seat.
Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a seat. Have a You can play games with me all day. I got all day. I got all day. Have a seat. The other one's in custody. I realize we are now at least caught up within an hour. I think those that want to go probably want me to take a break about now. So I'm going to take about a 5 to 10 minute break. I'll come back out and then I'll call the case. The court's going to stand in recess.
Good afternoon, Your Honor. Daniel Magoo, here in Dewey Juris.
All right. So on this matter, I was apprised you of your rights. I told you about the charges in this case. We get to the point of understanding that there is a certain peril.
At this point, the judge has clearly had enough of the back and forth. Instead of continuing the circular discussion, he pauses the proceedings entirely. This moment is brief but powerful. It shows that the courtroom operates on order, not endless debate. When that order is disrupted, even slightly, the entire process comes to a halt until control is reestablished. The judge's decision reflects authority and control under pressure. It also signals that patience has limits. Even silence here carries weight, emphasizing the seriousness of the situation.
In representing.
Listening, sorry. My notes, I apologize, Your Honor. I meant no disrespect.
And that the court will treat you the same as an attorney in the case. You understand, sir? Listen closely to my question. Do you understand that?
I do not understand.
You do not understand it.
No.
The court, you will be presumed to know the rules of procedure as well as the Michigan rules of evidence, that the court will not be giving you assistance in regard to this case.
What I'm trying to say, Your Honor, is I do not understand the charges that are pitting against me because they violate a lot of my rights. And the prosecutor served me the discovery packet on the 27th of last month. Since then, I have not received any kind of evidence or any kind of claims that I violated any kind of anything that day. So I'm here.
As the session resumes, the defendant changes direction and claims he does not understand the charges at all. This introduces a new layer of complexity as he begins referencing constitutional rights and lack of evidence. The emotional weight increases when he mentions losing custody of his son, but the court remains focused on a simple issue, understanding the charges, not agreeing with them. This moment blends emotion with legal confusion. It becomes harder to tell whether this is strategy or genuine misunderstanding. Either way, it complicates the process significantly.
Waiting for that to occur. So no, I don't understand.
Waiting for what to occur?
Well, under the rights to due process, Your Honor, 4th, 5th, 8th Amendment, there has to be substantiated amount of evidence to accuse me of a crime, like assault on a police officer, obstruction of justice, and resisting arrest. I take these charges very serious, Your Honor. Because of these charges, I have lost custody of my son, and I want to make sure that these justice is served and equity is ensured here.
Sir, I just asked you before whether or not you understood the charges.
And I answered you, Your Honor. I said I do not understand them.
Whether or not you disagree with them or not, is not the issue. The issue is do you understand what you are charged with?
I do not understand, Your Honor.
Is there a reason other than what you said that you do not understand?
I can elaborate a little further, Your Honor. I'm still waiting.
I wish you wouldn't. I just need to understand why you don't understand.
I'm trying to get there, Your Honor, if we could talk
I'm
about
not asking you whether or not you agree that you should be charged. I'm not asking.
Hey, the judge makes a clear effort to simplify the situation, explaining the difference between understanding and agreeing. However, the defendant continues to deflect, even suggesting they agree to disagree, which is not how legal proceedings work. This moment highlights a fundamental disconnect, where one side is trying to follow procedure while the other resists it entirely. The frustration becomes more visible in the judge's tone. Each attempt to clarify is met with resistance. The gap between both sides continues to widen.
Asking whether or not you believe that you did it. I'm not asking any of that. I'm asking whether or not you understand what you are charged with.
Can we agree to disagree on the legalese?
We are not going to agree to anything. This is not your game to play here. You play by my rules.
So you're saying that I have to say the words, I understand?
Sir, I'm not saying that you have to say anything.
Okay.
You know what? Here's the thing. I am not going to play this game with you.
I'm not.
So what? No, you are playing a game.
I'm not.
So no, you are. And do not interrupt me ever again. Do not. So what I'm going to do is I'm going to give you a week to think about it, because I'm not going to sit here, call your case up 4 or 5 times for you to sit here and to go through this whole, try to play some semantical game. So I will adjourn this out to December 12th, 2024. I will adjourn it to 9 a.m. or I will. Do not interrupt me.
I can object to
Do
that.
not interrupt. Do not. One more time. You're going. I've given you fair warning. I'm adjourning the proceeding out. If you are objecting to that, objections noted. It's still adjourned out to the 12th. Bond will continue. You
Your
may
Honor,
leave now.
I have constitutional.
You may
violation.
leave now.
Let's go.
The situation reaches a breaking point as the judge directly calls out the behavior as a game. With repeated interruptions and refusal to cooperate, the judge decides to adjourn the case. This is a decisive move, showing that the court will not entertain tactics that waste time or undermine the process. Authority is firmly re-established in this moment. The judge makes it clear that control will not be lost. This serves as a turning point where consequences begin to take shape. The courtroom dynamic shifts completely here.
I have a right to
You
a
may
counsel.
leave.
Do I not have a right to a counsel?
You want an attorney, you may get on an attorney, sir?
I need somebody to explain the problem here.
Do you wish to be represented by an attorney on this?
I do not need to represent myself. I'm presenting myself. I'm the only one that was there in this courtroom. No one was there. I don't recall anybody that was there that day. I'm the only one that knows what happened, Your Honor.
Do you wish
And I was
to be
violated.
represented by an attorney? I'm not going to sit here and argue with you. If you wish to be represented by an attorney,
Your Honor, I have constitutional violations
do
that
you
need
wish to be represented by an attorney,
to
sir?
take an oath to defend the Constitution of the United States of
Then,
America.
if you do not want to answer my question, Mr. Allen, he is to be removed from my court. Let's call the case of the People State of Michigan versus Daniel Magoo.
Good afternoon, Your Honor. Daniel Magoo.
All right. Mr. Magoo, you are representing yourself. I do have to apprise you that you are before the court on charge of resisting and obstructing a police officer. That is a high court misdemeanor, or what technically is known as a high court misdemeanor, and or felony punishable by up to 2 years, $2,000 fine plus court costs. There are great perils in representing yourself. In this, you have to understand that I am going to treat you the same as though you know the laws and the rules of evidence. I will not treat you worse because you are not represented. I will not treat you better or grant any favors or try to clarify anything for you. If, for whatever reason, during any point in this proceeding, you wish to be represented by counsel and cannot afford to hire counsel, counsel will be appointed to represent you. As I have in the past hearings asked you to acknowledge what I've said, I'm going to only indicate that I believe that.
Even after the adjournment decision, the defendant continues to argue, bringing up constitutional rights and speaking over the judge. The situation escalates to the point where removal is ordered. This moment captures the consequences of pushing too far in a structured environment where respect and order are non-negotiable. The tension peaks as control is enforced more strictly. What started as disagreement now becomes disruption. This shows how quickly things can spiral when boundaries are ignored.
You understand English, you believe that the words that I have said to you are understood, so that we don't get into, you need to remove the gum from your mouth. And
Thank you.
so I will not ask you to acknowledge. I will presume that you do indeed understand everything that I've said. Now, having said that, what are we doing with this case?
I'd like to move for evidentiary hearing or
You wish to have a preliminary examination?
preliminary examination. Yes, sir.
But do people have their witnesses available the second?
We can try, Your Honor, but before moving toward that, would the court be willing to make its inquiries about discovery? I am aware of the defendant having filed a writ of mandamus with the Court of Appeals of the state of Michigan.
Yes.
That was subsequently dismissed without prejudice by the Court of Appeals.
Correct.
Contained within that, though, there are allegations that my office has violated its Brady obligations and has not provided sufficient discovery. So I'm not sure if we're ready to move forward to preliminary exam. The defendant is saying that he doesn't have all of the discovery. That is the concern of the court. The record I feel compelled to make at this time, though, is that the people have provided, I do believe, were paid in this writ of mandamus that has been dismissed, appear to allege that things that have already been denied by this court should be produced. Furthermore, the defendant filed a motion.
When the case resumes again, the judge takes a different approach. Instead of asking for acknowledgement, he assumes understanding to avoid further delays. This is a strategic shift, allowing proceedings to move forward without getting trapped in the same cycle. It's a subtle but effective way to maintain control while keeping the process on track. The judge adapts rather than argues. This moment reflects experience and authority working together. The tone becomes more controlled and procedural again.
With no notice of hearing attached to it. So there's an outstanding motion in this case as well, no hearing date scheduled. So I'm hoping to sort of reconcile both of those things as whether or not discovery is complete, the defendant's prepared to move forward, and if he ever intends to file a notice of hearing to go along with the motion that I received in this case on 11/22.
Mr. Magoo, your response?
My response is that I thought this was the hearing that we were setting for the motion. So if I have to set a motion for a notice of hearing for that motion, I will do that today, Your Honor, promptly.
What about discovery?
I'm ready to move forward on my what I meant by my discovery comment was that there's still no exculpatory evidence as far as that I did anything wrong as far as anything that they've submitted. So if it was improper for the wording, Your Honor, I apologize, but my ultimate goal is have the prosecution present their evidence against me.
I'm going to indicate discovery is complete because I don't know what you're saying, because what you just said regarding discovery didn't make any sense. As it regards the motion, we will hear the motion the motion will be heard on date of exam.
Thank you, Your Honor.
With it at that point in time. So the people would have their witnesses available on the second.
We can try for the second, Your Honor.
Preliminary examination in person, January 2nd, 2025, 12 noon, that is before me.
Thank you, Your Honor.
Finally, the discussion turns to discovery and evidence, where the defendant argues that the lack of proof of innocence means a process is incomplete. However, this reveals a misunderstanding of how discovery works. The judge's response makes it clear that the argument lacks coherence, marking a critical turning point where credibility begins to weaken significantly. This moment closes a loop on the earlier confusion. It shows the consequences of not fully understanding legal procedures. The courtroom settles back into structure as the next steps are set. What we've seen here is a powerful example of how self-representation can quickly spiral when courtroom structure isn't respected. Every moment of resistance added friction, and every unclear answer slowed the process. In the end, the system didn't bend. It adapted and moved forward. If you found this breakdown insightful, make sure to like the video, subscribe to the channel, and we'll see you in the next video.